Okay, and I don't see the on-air online yet, so I'll... Once we see on air. Thank you for waiting as we work through the technical part of this. All right, we are on air. I see the Zoom connection has worked. All right. We are going to call to order the regular Planning Commission meeting for May 10th, 2022. Miss Erica, will you be taking our roll call this evening?
I will be taking roll this evening.
All right.
So Commissioner Bantz.
Here.
Commissioner Montalvo.
Here.
Commissioner Lampros.
Present.
Commissioner Waidola.
Present.
Vice Chair Kai.
Present.
Chair Simpson.
Here. Thank you. The consent agenda consists of the approval of the April 26th regular meeting minutes. Anybody have any correction or additions? Do we have a motion to approve the consent agenda?
So moved. Seconded.
All right, it's been moved and seconded that we approve the consent agenda. All in favor, say aye.
Aye.
Aye. Opposed? Motion carries. Council liaison announcements. We have this evening Councilor Giles is joining us from Zoom.
Commissioners, thank you for the time. I'm joining from home. We have a small COVID outbreak in our house, so keep them isolated. But we had a good meeting. We had a lot of community comments and participation. This is about the it was mostly about the area at the end of Redfern, that there's 2 houses that want to be put in on that, and so we're looking into, it was all done legally through Planning Commission and everything else, but we've just asked the city attorney to give us some options on what parameters, or what options are available to us, so that we don't have to take out so many trees or things like that, but frankly, right now we're just looking at everything, every option that's on the table, just so we can make a decision, that's legal. So, but other than that, we have nothing else in regards to the Planning Commission. So, thank you very much for your time and service.
All right. Thank you very much for joining us. Staff announcements.
2 really quick announcements. Your next meeting is May 24th. Currently, we have 1 hearing scheduled that night. And the next Sherwood West CAC meeting is still tentatively scheduled for June 9th at 5:30 p.m. And you can find the link and all information on the city's webpage.
Sorry, I didn't have that on my calendar. So June 9th, tentatively? Okay. Thank you very much for that announcement. Community comments. Community comments are limited to those items not on the agenda. And before I call up the first participants, if you intend to testify this evening, either in community comments or for the application, we ask that you complete one of these blue testimony cards and turn it into one of the members of the staff so that we can have your name and address for the record. So the first person for community comments is Susan Kloss.
I wanted to just talk a little bit more about process. One of the problems that we have with the city is in document retrieval. So if there's a land use planning action, the timing on that, you okay? Okay. The timing on the land use action, the staff report does not come out until 7 days prior to the hearing. So you don't know what the staff is going to share with the community, applicant, anybody that's interested. And the problem is that if you then as a community member want to get any kind of city records from the staff, there's a formal records request process. And the staff has up to 30 days to handle that request. So technically, you've got a problem because if you need additional information that you're trying to get for the hearing, you're stopped. You cannot force the staff, and the staff's already busy. I'm not saying anything about that. I'm saying that there is a logistic problem here. So I don't know what the solution is. I don't know if we have an expedited process that we could put into effect if we are looking for records that deal with the land use application that's going to be coming. I'm sharing this with the Planning Commission because you guys have a lot of intensive documentation that comes up in the course of your review and your public hearings. So if you're looking at it from a citizen's process, there are some records that are online. They only go back sporadically for 10 years. So, and I'm just, as an example, the Langer PUD has been here since 1995. So that's way more than 10 years. So if you're going to try to get historic information that deals with an application that is, if you can find it within the 10 years, it might be on the website. If it needs to go further than that, then you're really proscribed from getting the information that you may need to submit to the hearing. So I don't know what that solution is, and I'm asking the Planning Commission and the staff together, just like last week, hey, let's talk about this, because it doesn't need to be an adversarial process, and it shouldn't be. The staff is just doing their job. We're just trying to get information, but it shouldn't be that we don't have the opportunity to get the information. And so I'm asking, please, can we proactively work on that problem? And just as another example, there would be no way that we would have been able to get that 1995 code in the time frame that we needed for the land use hearing that's coming up. That I'm not trying to put this in that part of the hearing. I'm just saying that unless we already had a copy, because we've lived here for so long, it wouldn't have happened. And it has great bearing, in our opinion, on this land use action. So I'm just saying that let's take care of that disconnect. Let's figure out how to respond in a timely way at the staff level if there's a request that is specifically tailored toward a land use application that's got a time deadline.
All right, thank you very much. Obviously, your comments have been noted in the record, and we will be passing it on to the appropriate staff member for follow-up. We don't make staff policy, and I'm not sure if that's city manager or the city council, but it's been noted in the record. Thank you. Jim Claus.
Robert James Claus, 22211 Southwest Pacific Highway. Now, I wanted to talk to you about a completely different matter, which is this Urban Renewal District 2, $166.6 million. The way we found out about it was Roy Rogers called us and showed us he was in a meeting with the Mayor Keith Mays, where Mays said he had contacted us. He didn't. And we spent a lot of money on an engineer, legitimately, that we shouldn't have spent. Now, number two, you're depending on a broadband to make that work. You're not working on excess land value. Now, I assume all of you know what that means. Urban renewal only works if the excess land value covers the bond, and in this case of under $66.6 million. Dave Lumen was in charge of the last broadband disaster, and it was just that. It didn't work out. You had to give away to the school district and trade things. Looked like an Indian bazaar, to be truthful. Our engineer went to Julia Hyduke, and please notice I'm using names, and said, why did you not tell me they were in urban renewal? I said, did you ask her why they are not going to spend the $9 million until 2040? And they're blocking the property from developing, and in our case, we have to put the road in if we develop early at our expense with no refund. All of those things were decided, and the people that are impacted and will have excess land value were not told. Now, whether that's 14th Amendment violation or not, I don't know, but we may have to find out, because this is just ridiculous. We get brought into something and there are restraints against alienation on the property and you can't sell it. The first person that saw Robert Galati's insistence on that road walked away from the deal, and he had cash financing. He said no one but a lunatic would buy that property. Why? He said there's nothing left after the city's done, but if you wait 20 years, which the planning director of Transportation Washington County did not know. I hope you're beginning to see what I'm trying to tell you. You've got a problem of communication and direct misrepresentation. And apparently, your staff is told, don't talk. How many times in the Planning Commission have you held anything to find the properties that are involved in that? And what kind of plan? Every time we brought in a plan, it's been turned down. And I'm telling you, this thing of you having one standard for the political insiders and another standard for others wouldn't even work in a southern city like New Orleans. They would never tolerate that. We don't even know what's going on with our property, and it's got a restraint against alienation against it. You know what that road costs? About $15 a foot, a linear foot to put it in. And then we've got to give up $1 million worth of land to build it. Who's going to do that? Why would anybody put restrictions like that when there's huge excess land value? I'll tell you why. They want somebody else's property to develop first. Gee, I wonder whose. Couldn't be like a hotel that told, you better to go here, not there, or Walmart who was told, you go on Langer's or no place.
Thank you for your comments. Obviously, at this time, we cannot discuss any matter that has not been properly noticed per the Oregon public meeting laws. So we'll have staff look at the item.
I have exactly the opposite reaction. In Washington County, we stopped the meeting and others against the work. They said, we have to be able to comply.
So we're going to.
After I deal with that surgery, I'm sorry, I would have everyone here and then quickly get back slowly and they're going to do another operation.
So staff is looking into the item to see if we can get the hearing. We did test it prior to the meeting.
For the record, Gene, I can hear you just fine, totally clearly.
So for those people watching from the audience on the Zoom, there is a audio assistance device that we are attempting to get turned on and configured so that it is working. Brad? Mark, sorry. Are you able to hear us now through the device? All right, now we can hear. Perfect. Thank you very much. All right, we are through community comments, and we are moving on to our public hearing. And the public hearing on case file LU 2021-025 major modification to site plan Cascade, Columbia is called to order. Before I describe the procedures for conducting a public hearing, I want to note that the applicant has requested a continuance of this hearing to June 28th. The applicant has also signed a corresponding 120-day waiver. The Planning Commission can grant the requested continuance or conduct the hearing this evening as previously scheduled. The public testimony received thus far has been entered into the record and will be addressed as part of the public hearing on this application, whether that hearing is conducted tonight or at a later date. Staff, is there any further information you would like to address regarding the requested continuance?
Thank you, Chair Simpson. Nothing else at this time. Thank you.
Are there any questions for staff or any issues commissioners would like to discuss relating to the requested continuance? All right, then I have an opportunity to call for a motion. Do you have that language?
Do I need
Or I can,
specific different language, or that's fine? Okay.
I move the Sherwood Planning Commission continue the public hearing on the application for project major modification to site plan Cascade Columbia Distribution, case file LU 2021-025 to June 28th.
Seconded?
all right, it's been moved and seconded that we continue the public hearing on LU 2021-025 major modification to site plan Cascade Columbia to June 28th. Any discussion? All in favor say aye.
Aye.
Opposed? Motion carries. All right. All right, so now we're moving to the next one. Sorry, different script. All right, the public hearing on LU 2022-004 major modification to site plan Sentinel Storage 2 is called to order. This meeting was continued from our April 26th meeting. And the records have been kept open. The public hearing this evening will be conducted as follows. Staff will present the staff report, questions, if any, by the body for staff. We will then open the public hearing for testimony, and time will be limited as follows. The applicant will have 30 minutes split between presentation and rebuttal. Persons in favor of the application will have 4 minutes each. Persons opposed to the application will have 4 minutes each. The rebuttal from the applicant will be the remainder of their 30 minutes. Then no other testimony will be taken from the public or applicant unless the public testimony period is reopened. There'll be final comments by staff, questions of staff, if any, by the commission, and then deliberation by the commission. A decision may be made by the Planning Commission at the close of the hearing, or the matter may be continued to a time and date certain. If the matter is continued to a date certain, this will be the only notice of that date you receive. Staff will recognize people who have signed up to speak 24 hours in advance to provide testimony virtually. When it is your time to provide testimony, please state your name and address for the record. If you are in the audience this evening and wish to speak, please fill out one of the blue testimony forms and submit it to the planning staff. The chair will recognize people who wish to speak. When you come forward, please state your name and address for the record and ensure the green light is on the microphone base. Any questions should be addressed through the chair. In reaching a decision on the application, the commission must consider whether the application meets the relevant approval criteria in the city's land use regulations. Those criteria are identified in the staff report. The staff report is available online and at City Hall. The staff report was accessible to the public 7 days prior to this meeting date. The testimony and evidence must address these criteria or other criteria you believe to apply to the decision. Please note, failure to raise an issue with enough detail to enable the commission, the applicant, and the parties an opportunity to respond to the issues precludes an appeal to the City Council or Land Use Board of Appeals on that issue. Also, failure by the applicant to raise constitutional or other issues regarding proposed conditions of approval, again with enough detail to allow the commission to respond to the issue, precludes an action for damages in circuit court. At this time, I would like members of the commission to disclose ex parte contacts, bias, or conflicts of interest, indicate the nature and extent of the ex parte contact, bias, or conflict of interest, and indicate whether you intend to participate in or abstain from the hearing. Also, I believe Commissioner Bantz has a comment for the record.
Yes. As a matter of fact, yeah. I have no ex parte contact, but I did go back and rewatch the hearing from last time. And I've reviewed the material, so I'm up to speed.
And you will be participating.
And I will be participating. Yes. Thank you.
All right. Anybody else have any ex parte contact, bias, or conflicts of interest? All right. Does any member of the audience wish to challenge any planning commission member's ability to participate? Hearing none, the staff will now present the staff report.
Good evening, Chair Simpson and Planning Commissioners. Happy to be with you again in person, 2 in a row. I hope it stays that way. Eric Rutledge, Associate Planner with the City of Sherwood. Be giving a brief presentation. This is our continued hearing for LU 2022-004, Sentinel Storage 2 major modification. The applicant's requesting approval of a Type 4 major modification to an approved site plan for a new 3-story self-storage building located at 21900 Southwest Langer Farms Parkway. As mentioned, the application is being processed as a Type 4 land use application with the Planning Commission as the decision authority. The application timeline, we are here at the second hearing for Planning Commission. The previous meeting was on April 26th. Because of the 120-day deadline and potentially the council meeting on July 5th not taking place because of the holiday, Planning Commission does need to make a decision on this application tonight. If we don't get a 120-day request or extension from the applicant, and we will need to issue the notice of decision tomorrow. So just a fair heads up to you, Gene. I'll be reaching out, whatever the decision is, to get that signed and sent out tomorrow. And for the public, in terms of future dates, again, the notice of decision will go out tomorrow. If you provided your address as testimony, we will send you that notice of decision. The appeal deadline is May 25th, 2022. And then if it is needed, the appeal hearing to City Council would be on June 21st, 2022. Always good to just go back to the applicable criteria. So it's just shown on this slide for reference. Kind of went over an introduction, very brief introduction to quasi-judicial applications at the last hearing for this application. Just a reminder, this is a quasi-judicial application and the decision needs to be based on the approval criteria. The staff report addresses all of the criteria in detail. And if you have any questions on any of that, happy to go through it before you issue a decision. In terms of new testimony and exhibits received, so we have received some testimony since the release of the staff report, and then we've also added some exhibits to the record. The first, however many items are here, up until Exhibit D15. All of this was included in the staff memo and packet that went out last week on Tuesday. So you have the first 9 or 10 of these here, and then Exhibit D16 you have in front of you that came in this afternoon. A printed copy should be in front of you. Happy to answer any questions on that. And then for anybody in the public, this Exhibit D16 is also at the back counter over here if you'd like a copy of it. But that's everything that we have in the record to date. So a quick reminder on the location and zoning. It's on Langer Farms Parkway, outlined here in red, and the zoning on the property is light industrial. We did receive public testimony on the application. Most of the testimony, or all of it, was in opposition to the application and mainly focused around the self-storage use and the vesting determination from the city. So I just want to run through sort of at a high level, a very simplified level, what the sort of the history is on here, go over it again and just make sure it's clear. And if you guys have any questions, happy to answer any. So starting with the Sherwood Village PUD in 1995, the final development plan for the Sherwood Village PUD was approved on August 1st, 1995. The zoning and the code that was applied to the site at that time was light, or for this property that we're considering today, for the major modification, was light industrial. And in the light industrial code at that time, the code said that permitted uses in the LI zone include uses permitted outright in the general commercial zone. And if you go to the general commercial zone at that time, it would say that mini warehousing is allowed. So that's sort of the first action that was taken. And then in 2012, on March 30th, 2012, the city received an application for what's known as the Langer Farms subdivision. That'd be the eastern portion of the Sherwood Village PUD. The code, the zoning on the property at that time, March 30th, 2012, was light industrial. The code at that time said approved PUDs may elect to establish uses which are permitted or conditionally permitted under the base zone text applicable at the time of final approval of the PUD. And so the text at this time ties back to the text at the time of the PUD approval. So that's the second step. And then the third step is this Ors provision, which you've seen a lot recently, which says that after 1995, when a local government makes a decision on a land use application, only those local government laws implemented under an acknowledged comprehensive plan that are in effect at the time of application shall govern subsequent construction on the property unless the applicant elects otherwise. And so this is for, in the part that I'm not showing here, but the rest of the law states it's for a period of 10 years unless the local body states or has another time frame that might be shorter than 10 years. In our code, we don't have any other time other than what is in this law. We haven't elected to put a shorter time frame on this ORS provision in our code. And so just to summarize, the subdivision from 2012 vests the allowed uses on the site that were in effect in 2012 for a period of 10 years. And so that vesting period ends August 28th, 2022. And the code in effect in 2012 allows uses that were allowed in the general commercial zone in 1995. So that's how we get back to the 1995 code. This is spelled out in the staff report. I'm happy to answer any specific questions on this. We have our city attorney here as well who can answer any questions if you have any questions for him. Just a few other sort of general thoughts and clarifications from staff on this issue. There is testimony that states that the development agreement from 2007 and 2010, I guess, would supersede the Oregon revised statute. Staff does not agree with that. What we believe is that the development agreements did not waive the applicant's rights to a 10-year vesting period from the time of subdivision approval. The few reasons for that, the main one being that the subdivision occurred after the 2007 and 2010 development agreements. And so to conclude that the 2007 and 2010 development agreements foresaw the subdivision in 2012 and the ORS provisions, and somehow were proactively superseding that, it just doesn't make a lot of sense chronologically in the order of events. The other reason is that the language in the development agreements did not mention ORS 92040 or mention a waiver of the vesting rights under the state law, including for that future subdivision that, again, had not occurred when these development agreements were reached. And then we also heard an argument in the public testimony that because the entity that was involved in the development agreements is different than the applicant now, they should not be vested. The ORS pretty clearly, I included it here, but the ORS pretty clearly says that those laws are in effect at the time, govern subsequent construction on the property, not with that owner or anything else, but on the property. And so we don't agree with that conclusion that because there's a different applicant than the development agreement, that somehow they don't have standing. And then just a few other, and I guess just to go back to this point, you did also receive that Exhibit D16. I believe it sort of addresses from the applicant side some of the testimony that was received. Generally speaking, staff agrees with that exhibit, and just some additional information, and I think more detail than staff has gone into during the staff presentation. Happy to go over that with you as well. And then I had the slide last time, just a few very general revisions and a voluntary condition that the applicant has already agreed to around lighting. I won't go over them, but you'll see in the staff recommendation, we'll recommend that you approve the application subject to the changes and revisions on this slide, slide 9. So the staff recommendation for this evening is approval of LU 2022-010, subject to the findings and conditions in the staff report dated April 19th, 2022, with the revisions shown on slide 9 of the staff presentation. And then your alternatives for this evening, you can approve the application based on the findings in the staff report as revised by slide 9. You can approve the application with additional revised findings or conditions, or you can deny the application with revised findings. And happy to answer any questions.
So, do any of the commissioners have questions for staff regarding the exhibits or the presentation before we call up the applicant? All right, I have one blue card from the applicant, Marie Holiday. And then let's see, another. All right, thank you. And we have 30 minutes presentation and rebuttal, so, and if you just start with your name and address for the record.
Sure. My name is Marie Holiday with AKS Engineering, 12965 Southwest Herman Road, Suite 100, Tualatin, Oregon. And I'm presenting on behalf of the applicant this evening. As Eric mentioned, tonight up for your consideration is the major site plan modification to the existing Sentinel Storage 2 site located at 21900 Southwest Linger Farms Parkway. Prior to the continuance of the public hearing on April 26th, the applicant's team gave a detailed presentation We do have some materials here this evening if you'd like us, if it would be helpful to put another site plan up. Generally, the project involves replacement of a 14,850 square foot RV canopy with a 25,000 square foot building footprint, including a 3-story building. And the plans remain unchanged from the original public hearing. And the applicant concurs with the staff findings and conditions of approval, including the revised condition at the previous hearing. And the applicant's legal counsel submitted a letter before you addressing the public testimony received at the last hearing. And our team is available for any questions that you might have on that this evening.
That's it? All right.
That's it for now.
Okay, and saving 28 minutes and 44 seconds for rebuttal, or did the,
Unless you have any questions about the application.
or Seth King coming up to testify, or just available for questions?
He's available for any questions on any of the exhibits before you.
Okay. So before we call for proponents or opponents, are there questions? I think we can have public testimony and then rebuttal and questions from the commission for you, so.
I think I'd like to go ahead and walk through my letter here real quick.
And absolutely feel free. We could have 2 chairs up there if you wanted to move one up and sit. We'll sit there, so just again, state your name and address for the record.
Sure. Chair Simpson, members of the Planning Commission, good evening. My name is Seth King. I'm a land use attorney at the law firm of Perkins Coie, which is located at 1120 Northwest Cooch Street, 10th floor in Portland, 97209. And I'm here tonight on behalf of the applicant. And you have a letter that, from me dated today. That's the Exhibit D16 that was mentioned. And I just wanted to spend a couple minutes walking through that, make sure you understand that, and I'm here to answer any questions you might have about that. But that letter is responding to some testimony you heard before from Mr. and Mrs. Kloss that was in opposition to the applications. And the purpose of the letter was to explain the applicant's position, which is that we request that we believe that their contentions are off base, and we ask the Planning Commission to deny those contentions and approve the application. Just in summary, in terms of the substantive points we make in the letter, first of all, what the statute talks about, 92.040, is that when a subdivision is approved inside an urban growth boundary, the standards that were in effect at the time the application for that subdivision was made continue to apply to development up to a 10-year period of time. It could be less than that if the city establishes a shorter period. As Mr. Rutledge told you, the city hasn't established a shorter period. So in this case, the subdivision was approved in, Langer Farm subdivision was approved in 2012. And so that vested the site for development could occur pursuant to the standards in effect at that time for up to 10 years. And those standards included an amended and restated development agreement that was dated in 2010. That's between the city and the Langers. There is a provision under the statute where an applicant can elect otherwise, can say, I don't want to have those earlier standards apply. And Mr. Kloss contends that the applicant has elected otherwise by virtue of entering this development agreement, that was a instance where the applicant was saying, hey, we only want these standards to apply up until the development agreement expires in 2017. Or also we understand Mr. Kloss to say that was the city was establishing a shorter period than that 10-year period for the standards to apply, and that period ran in 2017 when the development agreement expired. But we think on those points that he's mistaken, because there's nothing in that development agreement that even addresses 92.040. Certainly, I would have advised the Langers that that they would need to expressly waive their rights under 92.040, and they didn't do that in the terms of that development agreement. Additionally, when there isn't any there isn't a reasonable argument that the city intended the development agreement to shorten the 10-year period of time either, because again, there's no statement to that effect in the development agreement. And then finally, the statute itself doesn't say, well, if the parties entered a development agreement, that somehow changes the time period under the statute. So for all of those reasons, we just believe that in this case, the development agreement was in effect at the time of the subdivision in 2012, that then thus became a standard that was vested at that time and continues to apply for up to a 10-year period. We're still within that 10-year period, so that would apply. And the implication for this case is that means that the uses that were in effect at the time that the PUD developed, or PUD was approved, back in 1995, that those standards and uses those uses can continue to be developed at this time, and that's what the applicant is proposing to do. Mr. Kloss, in his written testimony, had also presented sort of this far-fetched hypothetical scenario where if you had a development agreement where there was no expiration date, that would mean that effectively, like forever and ever and ever, the applicant and the city could just keep extending the agreement or replatting property, and that the vested standards would just continue to apply forever and ever. But that's very far-fetched. That's not this scenario. This scenario, the development agreement had an expiration date, so that has expired now. So that hypothetical doesn't apply here. What you need to be considering is the actual application in front of you. So that's very different than the hypothetical proposed there. And then the next point in Mr. Kloss's letter concerns the LUBA decision from the Group B v. City of Corvallis case, and we believe that he's misapplying that decision in his written statements to you. What LUBA said in that case is that even if at the time of the subdivision a specific development is not proposed, but the local government's approving a particular lot configuration and lot size that is premised upon a particular type or location of future development, then the local government can't, under the statute 92.040, apply different or conflicting standards to that future development. So what that means for Langer Farm subdivision is that the city back in 2012 approved the particular lots and configurations upon the Langers developing uses that could be developed at the time the PUD was approved in 1995, and thus the city is precluded from coming back and changing that now. The final point on that in the letter in response to Mrs. Kloss's testimony, she submitted quite a bit of information at that last hearing with Secretary of State information about different Langer entities, and you're not going to need to consult that because the development agreement in question runs with the land. It wasn't personal to any individual, so it would have, at least up until it expired, would have continued to apply to the property, and the benefits and the burdens of it would have run to the landowners. So that concludes the summary of the letter, and again, based on that, we would ask you to deny the contentions from Mr. and Mrs. Kloss and ask you to approve the application. Happy to answer any questions that you might have.
Going to 2012, which was 17 years, is that an extension of the 10-year, or was the 10-year not included in that? In other words, should it have not discontinued in 2005 and then renegotiated as a contract at that time?
So the 10 years did not begin until 2012 because it was not, it's not a product of the development agreement. It's a product of the subdivision, which was approved in 2012.
So 1995 did not include such a article.
it's a different type of land use action, is that?
The PUD was approved in 1995, and that was not a subdivision action. In 2012 was when the subdivision was approved, and that's what started the 10-year clock.
It's a little confusing to me, but.
He's asking where the 1995 language comes into play, and it seems like
Yeah.
1995 language was referred to, if I understand this right, by the 2012 action. It still referred back to that language, the development. Is that what I understood earlier?
And I don't know if.
Correct.
So,
Yeah. Oh, sorry.
Go ahead.
So what the code allowed was an applicant to elect to develop with the uses that were allowed at the time that a PUD was first approved, and that first approval occurred in 1995, and the Langers exercised that election and memorialized that with the city in the development agreement in 2007 and 2010. And so that was an election under the local code that vested them for that. It's a different type of vesting than has occurred with the subdivision.
So for layman's,
clear
for
as
new
mud?
commissioners, and I can ask Eric if we want to address it now or do it under deliberation, but I think it would be helpful for the commission. We have new commissioners, and it would be helpful to understand that the 1995 process, the phrase PUD means a planned unit development, where they take their land and make a determination that they are going to apply an overlay zone, and that overlay zone sets a certain set of criteria and regulations that follow that piece of property. So when you look at our colored maps in the city, there's different colors, but there's some that are hash marked, and those are planned unit developments. Like Woodhaven is a planned unit development. That entire area was not master plan, but a planned unit development, and that locked in a set of rules using the vehicle planned unit development. The subdivision that they're talking about is a different land use process that creates parcels, sort of, yeah. That creates parcels, so it's two different processes. One's creating an overlay, and that is its own process, and then there were some development agreements that occurred after that, but then the 2012 action is a different section of our code that deals with subdivisions, and that's what the ORS is specifically looking at, is when the subdivision action was taken. That's does that help at all? It's two different I'm trying to have an analogy that compares.
Well, I've read a lot of material, and it seems to refer back to the 1995 PUD quite a bit, and so
Right.
I'm getting confused as to the time variance between, we're going 12 years, 15 years, 17 years, length, and now we're even 27 years.
But a PUD,
And I'm just wondering, how long can this continue?
the PUD is perpetual, is forever.
So that's perpetual.
That's a PUD overlay is in place. Can we rezone a PUD? Maybe. It could be rezoned, but that would be like rezoning, going through an entire process to rezone. If we wanted to rezone the house across the street to commercial, it would be an entire legislative process to rezone it. So that land is zoned a particular shade. It's industrial, commercial, residential.
We can talk about this in a bit. I don't want to take any more
No,
of your time.
well, it's important to understand, for everybody. And if you're asking the question, other commissioners are also new, trying to understand it's two different processes, that the PUD process creates an overlay zone that, unless a legislative action happens, follows the property forever. The subdivision part of it is a different action that
After 2012.
It happened in 2012 and apparently has rules that last 10 years according to the ORS regulations because the city doesn't have any other more restrictive time frames. I'm trying to think, I'm looking to Josh to say, is there another analogy that would make sense that
My only hesitation is that procedurally I'd like to
allow?
do the questions and answer for the applicant, and
Okay.
then we can do public testimony, and then we can have, I think, a pretty robust
Okay.
discussion with staff.
Okay,
to
thank
answer some
you.
of these questions.
So I was trying to help. We do have a new commissioner, so trying to explain PUD and subdivision is two different processes. So go ahead. So,
Any other questions?
any other questions of the applicant?
Thank you.
I'm sorry, I was asking other people. So I'm a little unclear on the Group B decision. And can you just go through that one more time? Just re-summarize what you're saying, the Group B decision. So there's a statement that,
Sure. So how we construe that, so that was a decision made by the Land Use Board of Appeals, an appeal from the City of Corvallis. And what we understand the decision to say, there was a question that was before them, which was, well, when you approved your subdivision, if there wasn't specific development proposed then, do you still vest the standards that were in place then?
okay,
And so that was the question that was before LUBA. And LUBA looked at it and said, well, even if you're not approving specific development at that stage, but you are approving a subdivision that's premised upon future development, in other words, you're locating the lots and sizing the lots in a certain way to support a particular future development, then you can't change the standards. They're vested to apply the standards in place when that subdivision application was made. And so the question here raised by Mr. Kloss was, did the Langers in 2012 propose specific development for the subdivision? And at that time, I think if you're construing that decision, they didn't have super specific development at that time. However, there was enough in that decision where the city was saying that it was premised in terms of the use that was being approved, that it was based upon uses that could be developed at the time the PUD was approved. It was specifically referring to those types of uses and approved the subdivision accordingly. So we interpret that then that the city can't come back and change the standards now and take that right away. Does that make sense?
yeah, so if I were to restate this using a different type of example that's easier to understand in my world is a residential. So if I came in with a residential subdivision, I may ask for the lot sizes, but I really don't know what I'm going to build. I have up to 10 years to figure out what my residential building footprints look like, as long as I do buildings that are residential in nature, and me as an applicant or the city can't change it to retail commercial or something like that. Neither party can do that because you're locked in for 10 years. Is that what this decision is saying?
Yes.
Okay.
I would agree with your example.
Okay, so just trying to understand the interpretation of it. Okay. Sorry, it was new. Okay, I don't have any other questions. Thank you for explaining that. Wait.
Are there cases like this before LUBA where, I mean, this is not that kind of case where they hadn't figured out what they were going to build yet. This site is built. It's totally built and done, constructed, and you're wanting to rebuild part of it. Has that been adjudicated before as part of this? To your knowledge?
To my knowledge, no. But there aren't a lot of cases that arise under this statute.
Okay. All right. Well, thank you. Yeah.
All right, thank you very much. All right, so under my script, staff is to recognize people who have signed up to testify virtually. Did anybody sign up to testify virtually? Okay. Then we have two blue cards. We have no persons in favor of the application this evening. The first person signed up for opposition is Susan Kloss.
Susan Claus, 22211 Southwest Pacific Highway. The first thing I want to submit for this hearing is to request for the Planning Commission to keep the land use record open for 7 days per ORS 197.97, parentheses 6, parentheses B. There's new information that's been submitted to the record that I definitely want to make comment on, and I only have 4 minutes here. I'd like the record to be open for written record for 7 days for additional, and I have copies here for the commissioners, and then there's a copy also for the record. But part of what we're talking about here, and I understand the applicant is advocating, absolutely. I agree that they're advocating. We need to compare apples to apples and oranges to oranges. They want to be able to go back to a 95 code that has specific provisions, not just the uses that they wish to have 10 years later after a 2012 subdivision, but it has other provisions that if you are talking about keeping that PUD alive, you have specific responsibilities to do that. In this letter, I've just given some of the information. It's part of the reason why the 95 code was submitted to the record. If you go into the PUD section, there are positive obligations that the Planning Commission of all people, of all entities, have for that Langer PUD. If the whole thing is not built out or different parts of it are not built out on a regular basis, the Planning Commission has to meet and hold a public hearing and say if it's in the interest, okay? So that's something that's in that written document. I want to address also when they talk about the agreement, the termination, the agreement was 2007 in 2010, but the termination date was no later than January 1st of 2017. They got their approval and they got full build out on this site. Commissioner Bance is right. They got full build out for this site within that first application. What they're trying to do now is they're trying to use an ORS statute that they've actually elected out of because they didn't follow the 95 code. They didn't. We don't have all of these years of saying yes, we love the Langer PUD. Yes, let's keep going. We have none of that. We have other subsequent codes that have been used to just keep going with the Langer PUD, but we are picking and choosing what we want in that 95 code. If it benefits the applicant, okay, let them have the uses 27 years later on a piece of ground that does not allow those uses. They already have a build out. They got everything they wanted when they came in. If they wanted to do a phase 2 at that time, they should have said, hey, we're going to only build out this much. And then later on, we're going to build out 575 units. We're going to take out the middle, and then we're going to redo the whole thing. There was none of that. There was no contemplation there. They got everything done. That development agreement expired in January 1st, 2017. 5 years later, now they're trying to bootleg on this ORS statute that says if the applicant, or I mean, if the owner of the property elects, they can elect, okay? Either they stay with the old code or they go to the new codes. They went to the new codes by virtue of the fact that they didn't follow the old codes. So that's there. There's other examples through that 95 code. That's why the whole code is sitting in there. So my time is over, but please, I'm asking for the record to be open because there's a lot more to respond to based on information tonight, including what's gone on with, with the testimony that's coming from the Planning Commission, too. So, thank you very much.
Thank you. Was there a copy given to the applicant? Oh.
There's several copies.
The other person signed up to testify as an opponent is Jim Claus.
Robert James Claus, 22211 Southwest Pacific Highway. Now, I alluded earlier to can you get a fair hearing in Sherwood? I'm going to want to type up your remarks, Ms. Simmons. Because if you'd have said in my opinion or my belief or anything, but you were quoting as if it was the law. And I have never heard anyone say zoning is in perpetuity in my entire life. Now, I know Berkeley and Stanford don't have very good programs, and I'm sure you went to a better one. But I've never heard that in the wildest moment. The question here is exactly why we need another 7 days. They come in here and they think they've got it politically wired. Why? Guy Soper's got his hands sort of tied because guess who was on the city council? The applicant. Now, he represented him. I don't have an attorney that represents me and comes to the meeting. I don't have a chairman that stands and tries to explain what COI, well, they did a better job, I guess, on the Russian story than this one. Or was it worse? This is a big law firm. They don't need your help. I guarantee you. We can't come here and get a fair hearing, and that's what you're not understanding. Do you understand with the police powers, you pass the law, and if we break it, we are a criminal until we prove we didn't do it or the law is not legal. And it's on a rational relationship basis. That you could say, I passed this law because I think planting tulips along the road is a good idea, and I have to prove it's not. We come here under a terrible burden. And you're doing nothing but putting the burden on the citizens now. I cannot, for the life of me, understand how anyone would argue on behalf of an applicant and say they are not biased. I don't mind being biased. I've testified in front of the House Judiciary Committee a number of times in Washington, D.C., and I was biased, terribly biased for small business. And I admitted it. When my code got up to the Supreme Court in San Diego, I was biased. I wanted it passed, and it did. But my fellow alumni, Stanford, Rehnquist voted against me. So it must have been pretty left-wing. I don't understand what's going on here at all. That this application goes in, and at the last minute, we're expected to drop everything when I'm supposed to go in for another heart operation and fight this. Now we want the 7 days. Because I'm getting sick and tired of a city that was as gifted with as many assets as this city had, getting one flub up after another. Look at the roads we're putting in over there now. Why are we putting them in? Because Langer was zoned light industrial. Home Depot was zoned light industrial. At Biff, the zoning was changed. Now, Home Depot, they called a lumber yard. Home Depot. That's a little stupid. The largest retailer of that kind in the United States was now a lumber yard. This staff does things if they like you, and that's if you're in May's blessings. You get what you want. Now I come here and I find her arguing for that, and I find a lawyer that has represented Langer, the applicant, the LLC, sitting here. They've got money enough to hire one of the big shots. These are the guys that are involved in that brouhaha over the Russian thing, you know? They're big people. This is a big law firm. They're very capable people. Why weren't they here before? Why was the staff advocating for them? Most of us just want to live here. We're the largest owners in the history of Sherwood. No one's even come close to us. We donated the essence to the refuge. We donated your parking downtown. We donated the thing in Stella Olson Park. And we come here, merely want to be treated legally. and we can't get treated legally on our piece. What is it?
Okay, so we've had two people testify, and I have the first letter as Exhibit D17 and the second letter as Exhibit D18.
Want to,
Correct?
yeah, thanks, Chair Simpson. I want to clarify, I think we got one more piece of testimony, Erica? So I think we have three pieces of testimony. So I have is this one of them as well? I think so. One of them is a request to leave the record open for 7 days. We'll need to look at that and see if we agree that the ORS allows that because of the 120-day clock and need to issue a decision. So we might need some input from Josh on that one. Do you need the code section again, Josh, while we work through stuff? Okay. So that's number one. I think that one was introduced first. So do you have that one?
No.
Okay.
So that's D17,
It doesn't matter. We could do 20 or whatever. So what's-
19.
19?
D19.
So this one would be D19. And then which one are you referring to as 17?
Susan Floss dated May 10th is D17. That was the first one we were handed.
Okay. D17.
The second one, and the second one we were handed was RJ Kloss dated May 10th, which is D18.
Okay. And does everyone have a copy of D17 through 19?
I don't have a copy of D17. I read it as real quickly, then pass it down to Commissioner Vance.
Okay.
We have
Do
a
you guys
short
have
one.
copies for all the commissioners? Really all three.
Okay, so we'll take a recess and make sure that
But, yeah,
the
we can
commissioners
copy it.
get
Maybe we just copy it.
copies.
Say the one for asking, I can verbally ask for that. But absolutely, please copy that.
Okay, so we're short one D17. We have no copies of D19 up here, and was there another, something that was submitted to you, Erica?
No, those were the only three pieces of testimony.
Okay, and so we'll want to make sure that all commissioners have copies, and the applicant has copies of all three, and then we are going to take a 15-minute recess to allow an opportunity to read. The applicant will still have their 21 minutes of rebuttal time after they've had an opportunity to read the submitted testimony and prepare a rebuttal for that. And then at the same time, staff will be making, providing direction on the request for a continuance. And so at this,
I just want to clarify that the piece that Jim, his May 10th letter, there are some exhibits behind it. The letter itself, you guys received the record has the exhibits too. So that's just the clarification that I wanted to make. So there's just exhibits.
great. So there's additional exhibits that the commission does not have copies of.
Correct, and we'll get copies.
So seems like more like 20 minutes, reconvening at 8:30, so everybody gets copies of the documents. And then I would caution the commission that if you need to ask any questions, that you direct them to staff. There is one at a time. You can ask a staff member a question. We don't want to at all create a quorum by asking questions in a group. So if you have a question, we will have an opportunity for deliberations, and we'll get some more clarifications on processes and definitions that were used during the hearing tonight. So we are recessed until 8:30.
Will we remember to unmute our line so Counselor Giles can hear us?
Were you listening to us in the back?
No, but we got everything muted, but then Counselor Giles is like, I can't hear you guys, I can't hear you guys.
All right, we're back. Oh, dear. Ooh, we're reverbing. Is everybody back? All right. We're going to resume the Planning Commission hearing. And at this time in our script, we have received all of the opposition testimony, and the rebuttal from the applicant is our next order. And they have the remainder of their original 30 minutes, which is 21 minutes and some seconds left. Which, give just a second for staff to get the time on the clock. Or you can just start it and we'll round up a minute.
And I hopefully won't come anywhere close to using that much time.
I was going to say, the hammer comes down at 35 seconds. So, all right, thank you.
Thank you, Chair Simpson, members of the Planning Commission. For the record, Seth King for the applicant on rebuttal. And we're going to be responding to some new points that were raised in the letters that were submitted, D17, D18, D19 from the clauses. And first, some of the points they raised, they were repeating arguments they'd made before, and we've responded to those, so I'm not going to repeat that. But in terms of new issues, I think the primary new issue that we saw raised by Mrs. Claus was her contention that the applicant was kind of mixing and matching codes and was trying to rely on the use provisions of the 1995 codes, but not other provisions of the 1995 code. And I'll explain to you why that is. So the use election that we've been talking about here was allowed by a provision of the Sherwood Zoning and Development Code that was in effect in 2012, and what it said was approved PUDs may select or may elect to establish uses which are permitted or conditionally permitted under the base zone text applicable at the time of final approval of the PUD. So, in other words, that election is specific to uses that were allowed at the time of approval and not as to any other standards that were allowed at that time. So what the applicant did and what was memorialized in that development agreement was the applicant elected those uses from the date of approval, which was 1995, and didn't have the opportunity to opt into other standards, and so wasn't doing that. That's why there may be this sense that there are mixing and matching of codes, and that's not the applicant that's choosing to do that. That's just the way the city code was written at that time. All the applicant could do was elect uses. So I hope that makes sense. And as to other provisions that Mrs. Claus has raised under the 1995 code, I mean, we don't think those are applicable tonight to the particular application that you have pending before you. As to Mr. Claus's letter in D18, a couple of new issues we saw here. One was he contends that the statute, ORS 92.040 sub 2, is personal to the applicant, and thus that the only person who can exercise the 10-year vesting period is that applicant, and that the site plan modification applicant is different than the subdivision applicant, and so that they're not able to take advantage of that earlier vesting. And I think in his argument, he's inserting words into the statute that aren't there. In fact, what the statute says is that it's pretty clear that it's just vesting in general and that it's not for a particular applicant. What it says, and I'm reading subsection 2 here, when a local government makes a decision on a land use application for subdivision inside an urban growth boundary, only those local government laws implemented under an acknowledged comprehensive plan that are in effect at the time of application shall govern subsequent construction on the property. I mean, that's very much just talking about vesting in general. It's not so long as the same applicant continues to be there, or so long as it's just a vesting in general. And I think if the city were to interpret it the way that Mr. Kloss proposes, it would really work against the site plan modification applicant's rights, because they're relying upon that vesting just as much as anyone here. And then Mr. Kloss's other primary point that we picked up on was that he contends that, well, the earlier subdivision applicant, Langer Farms LLC, never really intended to develop a self-storage building that was 3 stories tall, and he thinks that the best evidence was the fact that that's not what they did before. And I think that I think he's reading too much into what the Langer Family LLC did or didn't do. It doesn't take away the fact that when the subdivision was approved in 2012, as we talked about earlier, that the city was approving a particular configuration and size of lots that was premised upon development that would be consistent with what was allowed with uses at the time that the PUD was approved. So I think that there doesn't need to be a specific intent that a 3-story self-storage building was going to be built in 2012 for the vesting to take place. And I think he's reading too much into the situation to say that that wasn't what the applicant intended at that time. And then the last point that you have before you is the question about holding the record open. And we believe that they are reading the statute incorrectly there. What Mrs. Claus was citing to was ORS 197-763 sub 6 sub B. And that does say that if you get to a continued hearing and that there is new evidence submitted, that a party may request that the record be held open to allow time to respond to that evidence. We believe that everything we've submitted tonight is new argument. My letter was pretty clearly legal argument. There weren't new facts there. There wasn't a new traffic study or anything like that was presented. It was all legal argument. I think it was wholly predictable that would be coming in light of the earlier arguments that they made. And I also believe that the Planning Commission gave them an opportunity to rebut tonight. And frankly, when I heard Mr. Kloss's 4 minutes, he didn't put a whole lot of energy into responding to my arguments. He seemed to put a whole lot of energy into talking about other things. So we don't believe that the Planning Commission is legally obligated to hold the record open as they've requested. I think that is up to the city whether you all want to exercise that right, and then I think if you do, then you've got to sort out some scheduling issues. But I think that is within the Planning Commission's discretion if that's where you want to go. And so I think that would conclude the applicant's rebuttal, unless you all have any further questions.
Do you have any questions for the applicant on their rebuttal? If I close, we will not be able to ask further questions of the applicant. So I just want to make sure everybody gets all their questions out to the applicant now.
What is the time frame you guys would be doing all this, if approved?
What would be the timeframe for the development to move
Yeah.
forward?
Mhm.
I don't know the answer to that.
I'll have you give your name and address for the record.
John Christensen, I'm with AKS Engineering, 12965 Southwest Herman Road, Suite 100, Tualatin, Oregon. The time frame for the construction activities would likely be next summer, summer 2023.
Thank you.
Other than the legal matters, we can ask questions about the actual application for the site layout. Any other questions that didn't get answered previously at the last hearing? All right, then, hearing no staff member telling me not to proceed, I'm going to go ahead and close the public testimony at this time. And then before we get into rebuttal and deliberation, I just wanted for people watching from the audience that the Planning Commission is a group of volunteers. We are citizens that are doing the best we can, and we lean on staff, and me personally, the staff and the city attorney when we're making decisions or comments, and in an attempt to assist a fellow commissioner in trying to provide information in a process. It is always just in the best interest of the process, and obviously it's my opinion because I'm a citizen volunteer, but I do rely on staff and legal counsel to ensure that what I'm saying is accurate to the best of what we can do right now. So that being said, we now lean towards staff to provide clarification on the rebuttal we received from the applicant and our proper procedure. There was a question raised from a member of the audience to confirm that our Zoom feed is still working. So if we could just take a 1-minute technical review. And thank you for bringing that to us. So there's on-air YouTube live, and then there's the Zoom meeting where people can dial in, I believe, correct?
Yeah, you may have gotten dropped from the Zoom link, maybe, but just check the YouTube and it was live, so we're broadcasting. So I think we're okay in terms of the general public being able to view and see. I think it's probably an issue with those participating online. Do you guys have anyone else online?
We just tried it right here and it was working.
Yeah, you guys don't have anyone participating on Zoom though as an applicant?
Our architect probably dropped off.
Okay, yeah. I think that if the public testimony period's over, you didn't have questions for the architect, then I think we're okay, so.
I think we were muted at the time. He couldn't hear us.
Yeah, I think it was just an issue.
Okay, so the issue regarding technical issues was the Zoom related, that we are YouTube live streaming, and it is actually being recorded still. So there's still a auditory video record of this evening, so.
Correct.
Phew, all right. Take something that's complex, add a remote version to it, and then bring it back as a hybrid with a bunch of volunteers and see if there's no glitches. That's still, volunteers doing the best we can with what we've got. So we lean to staff now again to the question of the rebuttal that we received from the applicant and our course of action going forward.
Yeah, thank you, Chair Simpson. So I'll just start with the process. We have a request to leave the record open for 7 days. We've taken a look at the information that was submitted and just a few clarifications. The request to leave the record open was in response to Exhibit D16, which was submitted by the applicant. It's dated May 10th. Just a clarifying note on that, it was submitted via email to staff and posted online on the city's website prior to the hearing. So it was also delivered in paper form, but the first delivery was electronic format and then posted online and made available to the public. But I think more importantly than that, staff agrees with the applicant that the information in Exhibit D16 is not new information. It's a rebuttal to information that was already in the record. Just going off of the title here, it's titled Applicant's Response to Clause Testimony. And so even in the header here, it's indicating that it's a response to testimony that's already in the record and not, is it new information we're calling it, or new evidence? So we're not seeing this as new evidence that would then require additional time for the public to review. Examples of that would be a new traffic study that hasn't been into the record that had alternative findings in it, photographs that haven't been presented into the record before that the public would need to review. But this piece of testimony from the applicant, Exhibit D16, is very clearly a response to information that was already in the record, and because of that, we don't believe that the city is required to leave the record open for 7 days. So leave it up to you if commissioners feel like more time is needed. You probably have to work that out with staff and look at the timeline pretty closely and maybe talk to the applicant as well about an extension. But if the Planning Commission is comfortable issuing a decision tonight, we think that it can be done. So that's process. And then in terms of Exhibits D17 and D18 that we received, we agree with the applicant as well that most of what was raised in here had already been raised by the individuals providing the testimony. The Exhibit D16 that I just talked about responds to much of that, and staff has also provided staff findings in the staff report and also sort of elaborated on that a little bit tonight during the staff presentation. And we don't believe that any of the material that was submitted tonight would change the staff findings or recommendation on the vesting determination for self-storage use. So staff has not seen any changes that we would have in terms of findings or recommendation or conditions based on the information. But if you guys have specific questions about anything in here, happy to answer questions. Just as an example to let you know, we've looked at it and don't believe that there's any issues. Just as an example, Exhibit D17. D17 states that the Planning Commission, and this was provided in the verbal testimony as well, that the Planning Commission would need to do kind of a two-step process to change the PUD, do a modification to the PUD. This proposal in front of you tonight is not for a modification to a PUD. It is a site plan modification. And so what is being proposed is not a change to the PUD. They're coming in under the allowed uses of the PUD and changing the site plan while utilizing the underlying use that's already allowed as part of the PUD. And so it's really not a change. A change to the PUD is not needed, as is stated in here. Other issues, again, just kind of the same issues about ownership and the sort of name on the application for this major modification not being the same as the party to the original development agreements and the original PUD, and some previous applications. Again, we stated this in the staff presentation. The ORS pretty clearly goes with and governs subsequent action on the property, and does not, if the property sells, it does not void that ORS regulation. So again, we didn't see anything in here that would change the staff recommendation or findings, and happy to answer any questions.
All right. So, anybody have any questions? Yes. You have to hold it, yeah.
Okay. Just a point of clarification for the August 28th vesting target. Does that mean that they have to get their approval and be out of the appeal period by August 28th? Or can you clarify that timing?
Yeah, that's a very good question. So they have submitted for the, I don't know that we have answered that question as part of any type of staff, findings or anything like that, but they applied for the application prior to August 28th. And so, general, and Josh might be able to give the ORS or ORA, but, you are sort of, you're allowed to sort of continue your application even if, for example, the development code changed or the zone changed, we wouldn't apply that to the current application in review. And so as long as they, at least how we're seeing it now, even though we haven't clarified it through a staff report, since they applied for this development prior to August 28th, they would be okay. And as long as they got the approval, we would, and the code has a provision that will have another sort of, it's either a year or 2-year date for this approval, for the modification approval to expire. And as long as they get their building permits prior to this specific approval's expiration date, they should be okay.
Well, before I ask,
Go ahead.
You're looking at me. Okay. Before I ask further questions, I do want to give Mr. Soper an opportunity to speak to something that came up in testimony where it was stated that you worked for the applicant or worked for the applicant. So I thought I would just ask you, have you done so, or the Langer family at all, or do you still? Why don't you speak to any of that?
Sure. Thank you. I appreciate the
opine on
opportunity.
things legally.
In my career as an attorney, I've represented a total of 2 clients, Coos County and the city of Sherwood. If you count time during law school, you could add the Oregon Department of Justice and a handful of low-income clients at the Lewis and Clark's Legal Clinic. So I've never represented the Langers, and no Langers were even on city council during the time that I've worked for the city of Sherwood.
Thank you. Yep. So is the PUD from back then still actually in place? So if this, because one of the things I'm kind of getting hung up on here is it doesn't, normally this kind of thing reads like, hey, we're in the middle of developing something, we want to make a change. This whole thing is already developed. In practice, it almost feels like a redevelopment of something. We're going to tear down a whole building and then rebuild something else, which seems like it would fall under different categories. But because of the way the law and chain of everything is written, it's able to go through this major modification. So I'm just curious, if this had to go that route, what would current PUD rules say? Could they still build a mini storage under current PUD? Do you know? No, they could not. Okay, so they're totally reliant on this chain of connection through this process.
Yes.
Okay. Interesting.
They would come in under the uses that are allowed under today's light industrial code.
Okay, have we had something like this before where it is developed and we're seeing it be requested in this manner, where it's developed and now an applicant wants to use this kind of language? I mean, basically what I'm getting at here is if we do this kind of thing, are we setting some kind of precedent where you can, down the road applicants be like, oh, I built this whole thing and then 10 years later, oh, actually I want to totally change it. I'm going to use this modification here. What are we setting here for this?
So I think the first thing just to make clear, which I think it is, but I think it's worth restating, is that after August 28th, 2022, they could not apply for these uses again. So just to be clear, that there is absolutely a back-end date to this. It's August 28th, 2022, and so it's not some weird thing in perpetuity that's going on, or that there's going to be a new deal struck because on August 28th, 2022, that's it. They could potentially come in for, a zone change or something like that and sort of, legally go through the process, get council approval to change the allowed uses on the site. So I just want to clarify that. In terms of any type of precedent setting, I think this is a pretty unique situation where you have a PUD and just sort of, going back to the slide of the sort of, we're here now and we go back to the subdivision, and then from the subdivision, we go back to the 1995 code. I know it's, you're kind of going from one to the next and chaining it all together. I think that's very unlikely to be another situation like this. I don't know if Josh has anything to add, but I think it's pretty unlikely. PUDs, we have much more residential PUDs in the city. We still get them at times. Less common to get industrial and commercial PUDs. But I don't think we're going to get this situation. I never say never, but I think it's pretty uncommon that we would see this again.
Yeah, the only thing I would add to that is the statute, the Ors 92040, says that it applies to subsequent construction on the property. It doesn't say the first time there's construction on the property. It says subsequent construction on the property. So my reading of that is that during that 10-year period, any construction on the property, those rules apply. The other thing is if the city is concerned about these 10-year periods, the statute also allows us to set a shorter time period. So if we're concerned about setting a precedent and these types of situations coming up in the future, we have the option of changing our code to say it's not going to be 10 years anymore, it's going to be 5 years or 7 years or whatever period.
One of the arguments that has been made is that this has to do with the property and not the applicant. The two things are totally separated. When I read this paragraph, I could see the argument. I could see an alternative argument. The whole context of the paragraph has frequently the applicant and the property together, even within that sentence. You could almost read it to imply that they go hand in hand. I don't know that that's whether it has been, and that's kind of why I was asking, are we aware of other cases, or what is there in case law around? Has this been gone to, over this issue? Is this actually in case law that they really are separate? That this is talking about two different things, that it goes with the property and the applicant is totally separate?
I have not seen any case law that says that addresses the question of whether ownership changes defeat the statute. So I'm not aware that's ever been litigated.
No.
I think from my perspective, when I'm trying to interpret the statute, I'm also thinking about the context and the intent of the statute, and that if it were tied to the ownership of the property, that would undermine the legislature's purpose in creating that statute. If you think about it, commonly in a residential subdivision, a subdivision could be approved and the lots sold off individually for each property owner to construct. My parents recently purchased a lot in that situation. And if the city had changed its code subsequent to the subdivision approval, and then the lot was sold, and then my parents wanted to build their house, and the rules wouldn't allow them to build a house there anymore, that's the kind of situation that the legislature was trying to prevent. Once you approve a subdivision, that you lock in the right to build that subdivision under the code that was in place at the time of the subdivision.
And this same statute applies to both these cases, including the hypothetical you just mentioned?
Well, my parents live in Michigan, so no, but
well,
it does apply to residential subdivisions, yes.
Okay.
Yeah.
Okay. So that's how you could interpret this then? Yeah, that they kind of go, follows the property. All right. And I do recognize there's also this agreement in here that states that it follows the property as well, but the agreement, and I think this was brought up, has an expiration date that's in the past as well. So I think we're kind of hanging on this Oregon statute to make the argument. Okay. Okay. Thank you.
Do we have any other questions about process, application? ready for a motion, I would entertain.
I'm more than ready. I move the Sherwood Planning Commission approve the application for project case file LU 2022-004, major modification to site plan Sentinel Storage 2, based on the applicant testimony, public testimony received, and the analysis findings and conditions and revised conditions and changes in the staff report as noted on slide 9.
I'll second.
All right, it's been moved and seconded that we approve LU 2022-004 major modification Sentinel Storage 2 based on the findings and conditions as modified on slide 9 in the staff report. Is there any further discussion? I do want to say before we vote that it's a very complicated matter. We are volunteers trying to interpret a lot of code and a lot of information, and we are relying on information that's supported by testimony from, and it's not testimony, it's our staff and our legal counsel from the city providing us direction. So I feel more comfortable in making my vote knowing that Josh Soper and Eric Rutledge have been here helping clarify the process and the information that we're being given this evening. So, any?
I just had a question. Do we need to make a finding regarding the continuance request separate, or is that roped into the motion?
It's a good question. What I would do normally is just, so when we issue, you do your deliberations, I would do a summary at the beginning of the notice of decision that just kind of captures, any sort of key issues, and so I'll put that sort of at the top of the notice of decision summarizing the hearing. Do you think that's enough, Josh, or do we need to do anything else there?
A request was made and Planning Commission did not take any action to grant it. I think that's sufficient.
We don't
So
need
also
to take a
through the
separate
minutes.
vote or anything on it.
Yeah, we'll also capture it through the minutes.
Okay, thank you. All right, hearing no other questions, all in favor of the motion say aye.
Aye.
Opposed? Motion carries. Thank you very much. And for clarification, you're going to want us to return all the binders and all the exhibits, including the first packets that we received.
If it's related to this application, yeah, you can give it back to us. Yeah, that'd be good, just in case, it'd be good. Yeah, thank you.
Just want to make sure all the documents get back to you. Okay, so moving on to our agenda, are there any commissioner comments before we adjourn? All right, well then we are adjourned. Thank you very much for this evening.